until all our daughters are safe, until all our children have families, until all our families have homes, until all our parents are cared for. We'll be here.
Welcome to Community Spotlight. I'm your host, Leah Hasledge. Today's Spotlight is on Legal Aid Society with a focus on record sealing and CQEs, both very important with the re-entry process. Our first guest is Jerry Meter, who is a volunteer with Legal Aid Act 2. Welcome, Jerry.
Thank you.
Let's start with record sealing. And people have heard that term before, but what exactly is it?
Well, record sealing is simply the process the court uses to take an individual's criminal records and make them unavailable for the average person. It's often referred to as expungement, and technically it's not really expungement because expungement is where you take the record and you completely erase it. That's not what we're talking about here. Sealing a criminal record is where they simply make the record unavailable, and it's still going to be available for certain officials, like law enforcement people can still see it. Certain state licenses, if you apply, for example, to be a nurse, that nursing authority can look behind the seal. And certain jobs that deal with vulnerable populations like children, if you want to be a teacher, for example, or nursing homes, for example, they can still see it. But by and large, most of the people, the average public, cannot see a record that's sealed.
Why should someone have their record sealed?
Well, the big reason is because it helps you get jobs. If you apply for a position and your prospective employer does a criminal records check, and you come back with a criminal conviction on your record, it may be that you're not going to get that job. So this will help your chances in getting a job, but it's not just about jobs. If, for example, you're applying to rent an apartment, your landlord may want to do the same thing. He may want to do a criminal records check. And if they do, and they see your name as having a criminal history, they may go to the next applicant.
And it's more common for that now, correct?
It is. It's a real problem. So having your record sealed can help you not only with your chances of getting a job, but can also help with housing. And it can also help you for some situations where you're trying to get into educational programs, there may be credit applications, or other benefits. Basically, anybody who's doing a criminal records check, if they're doing the criminal records check and you can seal your criminal records, you should take a look into it.
Definitely. Now, I know the law is different in every state, but for the state of Ohio, who is eligible to have their record sealed? Because it can't just be anybody that has a conviction or a felon.
No, it's not. In fact, the rules, I mean, this is the law. The rules are very complicated. So what I'd like to do is I'd like to give you the basic rule and then talk about all the various exceptions, and there's a lot of them. So you kind of need to know both the basic rule and some of the exceptions. The basic rule is that you're eligible to have your record sealed if you have no more than 2 criminal convictions nationwide at any time in the past. And only one of those 2 convictions can be a felony. So if you have 1 misdemeanor, you can have your record sealed. If you have 2, same thing. If you have 1 felony, in most cases, you can have your record sealed. But if you have 1 felony and 2 misdemeanors, in other words, 3 convictions, then you're not eligible. Or if you have 2 felonies, you're not eligible. So the rule is you can have up to 2 convictions, only one of which can be a felony to be eligible. Now, there are a lot of exceptions.
Right.
The big exceptions there are traffic offenses. Now, traffic offenses don't count against those 2 convictions. With the exception of drunk driving or OVI, operating a vehicle under the influence of alcohol or drugs does count. But you know, if you have 5 speeding tickets, you should probably drive more slowly. But those don't count against a 2 conviction limit. The other thing that doesn't count are so-called minor misdemeanors. Minor misdemeanors are those offenses that are only punishable by a fine. They're very low-level offenses. And those kinds of offenses that don't count, those minor misdemeanors, can be things like disorderly conduct, very low-level disorderly conduct, Misuse of public transportation, that's where you get on a bus without a ticket and you get fined for that. Or if you have loud music in a car and you get fined for that, those are often considered minor misdemeanors. Now, not always. Some jurisdictions have different rules, but those are sort of classic examples. Those don't count against the 2 conviction limit. So, again, the rule is you can have no more than 2 convictions, only one of which can be a felony, but we don't count traffic, we don't count minor misdemeanors, and we don't count things that aren't convictions.
So if your license suspended?
Well, that would be a traffic offense, and that would probably not be included. Okay. But it also doesn't include things like dismissals. So if you're brought up on a charge and the case is dismissed, well, that's not a conviction that counts against that 2 conviction limit. Or if you go through the whole trial and you're found not guilty, then that doesn't count either. So those, you can put those aside too. It's just the convictions that count. And by the way, often people are charged with an offense but are convicted of a lesser offense. Mm-hmm. It's only the offense that you're convicted of that counts.
So you can be charged, but that doesn't matter.
It's not the charge, it's the conviction that counts against that 2 conviction limit, right? So we've talked about traffic, minor misdemeanors, dismissals, and acquittals. Those are the exceptions to that 2 conviction limit. But it doesn't stop there. There's more. There's a waiting period. So if you have a misdemeanor, for example, let's say you have a petty theft conviction that you want to have sealed. Once that conviction is completely done, that trial is completely over, and all the effects of that crime are over, you still have to wait 1 year before you can file. Oh. Now that's important, especially if you have, for example, probation. You have to wait till that probation is done. So if I'm convicted of a petty theft, let's say, and I have a 1-year probation period, today I get convicted, I have to wait 1 year until my probation is concluded, and then I have to wait 1 year for the waiting period to actually apply to have that case sealed. For felonies, the waiting period is 3 years after the case is completely done. And there are other time limits, but those are the big 2, the 1 year for misdemeanors and 3 years for felonies.
Is there a breakdown when it comes to felonies as far as what can be sealed and what can't?
There are. Not every case is sealed. So let's say, for example, that you're eligible to seal your records, you've waited the appropriate time, and you want to go ahead and seal. Some cases simply can't be sealed. Now, one of those is the OVI, the operating a vehicle under the influence. That can never be sealed. Even though it counts against you, you can't seal it. So those drug driving cases, you can't, or driving under the influence of drugs, you can't seal those. The more serious crimes you can't seal. The felonies, the 1st and 2nd degree felonies you can't seal. The offenses for which there's a mandatory minimum jail sentence you can't seal. And then the 2 other areas you can't seal are crimes of violence that are more serious in nature. The 1st degree misdemeanor, the most serious misdemeanor crimes of violence cannot be sealed, and felony crimes of violence cannot be sealed. Now, there's an exception. There are always exceptions. Assault, 1st degree misdemeanor assault cases can be sealed, but if you have a case of domestic violence, for example, that's a 1st degree misdemeanor, that cannot be sealed. And finally, ordinarily, you cannot seal cases where children are the victims of the crime. And you can see why that is. I mean, the society has decided that there are some crimes that we need to continue to know about. Yeah. So the very serious crimes cannot be sealed, the drunk driving cannot be sealed, and crimes involving violence or children often cannot be sealed. So those are the exceptions.
Now, what if, say, someone was convicted of a crime in Cuyahoga County, but then they end up moving somewhere in Kentucky?
Right.
How does that all work when trying to have it sealed? Because it changes a state.
That's a very good question. So each state has their own rules. Now, I'm talking about Ohio's rules. And I'm only talking about sealing Ohio records. If there's a conviction in Kentucky or some other state, then that state's rules would have to come into play with regard to sealing those Kentucky criminal records. But we would count those Kentucky convictions as convictions against that 2 conviction limit. Yeah. So that's important to know.
I
was going to say, when you apply for that job or you apply for that license, they're likely going to conduct a nationwide criminal records check. So they're going to know what convictions you have throughout the country and in the federal system. So if you're looking to have your records sealed, you can't pretend you don't have those because they're going to find them.
So no matter where you are, it's
No,
still going to come up.
That's right. In Ohio,
Okay.
they're going to find those. Before they seal your records, they're going to take a hard look at you.
Now, what is the process to get your record sealed?
Well, the first thing you have to make sure before you try to get your record sealed is that you don't have any open cases in any other courts. Before you even go to court, you have to make sure that that case that's still pending, even if it's a traffic case, is concluded. If you go into court to have your record sealed, you have to have nothing going on. And if you do, they're going to make you wait. But once you're ready to seal, then what you have to do is you have to go to each of those courts that has records on you. So it's not uncommon for people to have convictions in Cleveland and multiple suburbs, for example. They have to take the paperwork for each case to each court and file them. It's a little complicated. Before you prepare those records, those pleadings, to have your record sealed, it's usually good to talk to an attorney because of all the complications that I've only touched on, some of the major ones. And if you don't have an attorney you can always go to the local bar association for a referral, or you can contact your local legal aid society or equivalent and see if they're able to help you with those documents.
Oh, that's wonderful.
Yeah.
Because, like you said, it's a very complicated process.
It can be, yes.
So is there anything else with record sealing that you think the viewers should know and be aware of, whether it's the process or just what record sealing is itself?
Yeah, I think the main thing to consider is, if you think you're close to being eligible, look into it. I mean, because there are so many nuances. It may be that you think you're eligible and you're not, or hopefully you think you're not eligible and you really are. The other thing I would mention is that when we talk about sealing criminal records, we're really talking mostly about those first, second, third, fourth degree misdemeanors and felony cases. Some cases you can seal almost at all times, and those are the minor misdemeanors that I mentioned earlier. Those acquittals and dismissals, you can always apply to seal those cases. Now, the process allows the prosecutor to object, but that's pretty rare. And in most cases, we've found that clients are actually successful in getting their records sealed.
And it's really helpful for anyone with a re-entry process, trying to get back into society and start all over.
Absolutely. Not having your criminal record show up when you apply for a job or housing can mean the world.
Well, thank you so much, Jerry. We've learned so much right here.
Thank you.
We really appreciate it.
Thank you for having me.
And don't change that channel, because when we come back, we're going to have Andrew Torres with us to discuss CQEs. We'll be right back with more Community Spotlight.
One in 6 seniors faces the threat of hunger, and millions more live in isolation.
America, let's do lunch.
Drop off a hot meal and say a quick hello. Volunteer for Meals on Wheels by donating your lunch break at americaletsdolunch.org.
Welcome back to Community Spotlight. I'm your host, Leah Haslage, and today we're talking Legal Aid Society, and in specific, record sealing in CQEs. Our next guest is Andrew Torres, who's a paralegal with Legal Aid Society. Welcome, Andrew.
Thank you for having me.
So tell us, what is CQE?
So a CQE stands for Certificate of Qualification for Employment. And what that is it's a certificate which a court may grant to someone with a conviction history, which shows good faith that this person has been rehabilitated and can be employed or granted a certificate by certain state licensing agencies.
Now, what exactly more so does that do?
So in the first half of the program, you heard about record sealing, and as the gentleman Jerry mentioned, the sealing statute really only covers a covering of the records, allows it to be more secured. In most cases, it doesn't expunge or delete it entirely. And particularly, you heard that the sealing statute does not remove barriers which may be holding someone up in professions where they may be around children, with other vulnerable populations like the elderly, or in healthcare professions. And the CQE was written by the state to really help assist folks who are experiencing those barriers. So, say you have a record and it's been sealed, you still may go to apply for a job, for example, as a nurse, or you may apply to get your nursing license, and you still may be denied because there's certain other parts of state law which say that there's an automatic barrier or even a discretionary barrier which prohibits you from having that license. And so the CQE is a mechanism by which you can have a court say this person has been proven rehabilitated and should be considered on an individual basis to have their to be granted the certificate and then go on to either earn a license or be considered for that employment opportunity. Now, it's important to note it doesn't guarantee employment or guarantee licensure, but it's another option. You know, it really is helpful for folks because, like I mentioned, folks that may be eligible for sealing and have had their record sealed, it may assist them in these cases. It also can assist people who aren't eligible. So, you know, as Jerry mentioned, there's very strict requirements around the number of convictions you can have, right? One of which can be a felony. A two conviction limit. In the CQE process, there is no limit on the number of convictions. You could have 3, right, which just puts you over the bar for sealing, or you could have 6, right? And it's important to know that because, you know, we want really, with a reentry perspective or a reentry focus, to you know, reintegrate people into our society as employees, as people that work with us in different places in our communities. And so the CQE really presents a great opportunity for folks that, you know, are just beyond the reach of the sealing process.
You said up to 6. I mean, is there still a limit though, as far as like how Jerry mentioned earlier, like that if you have this kind of first or second degree felony?
Yes, there is. Yeah. So, you know, and again, 6 is not the limit either. It could be 10, it could be 12, right? The important thing to know, though, is that it doesn't remove all barriers, right? So the idea, again, is that the CQE removes employment or license-based barriers that someone with a conviction may be experiencing. It's important to know, however, that it doesn't apply to all barriers. So, for example, if you have a barrier that has taken away your license, for example, a DUI or an OVI charge, right? You cannot get your license back for that. There's other certain, again, violent offenses in which, you know, if you are subject to a sex offender registration requirement, it cannot remove that barrier. And there's a long list of them.
Violence, I'm sure, too.
Yeah, crimes of violence, in which, again, it's not tied to the type of conviction, but rather the barrier which you're experiencing. It gets a little specific and a little nuanced, so you may want to reach out to a legal aid professional or an attorney to find out what barriers, one, you're experiencing, and two, whether or not that barrier can be removed, or at least you can have discretion with regard to that barrier from an employer or from a licensing agency.
Now, does CQE benefit the employer at all?
It does, actually. So a CQE, as part of the statute, as part of the state law, says that an employer is protected from negligent hiring claims. So in other words, if someone was convicted of theft and then reoffends while working for an employer, that employer is provided immunity through the state law. So employers, we like to look at it as sort of a win-win situation where you're allowing someone to reintegrate and to re-enter society through gainful employment or through gaining a license, and similarly the employer doesn't have to go into the process with any sort of fear they may have of what happens if.
They're going to have a repercussion.
Exactly.
Yeah. Now, who should apply for a CQE?
So again, anyone, whether you've sealed your record or not, you want to take a look at the CQE because, as we mentioned, there's certain cases in which a record sealing may not help you all the way, right? Because the record still exists and is more secure, but it exists to some people. And if you cannot get your record sealed, then you want to take a look at it because it may be the only relief available to you. Important things to know are, time limits, right? When can you apply? So if you've been convicted of a crime, if it's a misdemeanor, it has to have been 6 months from the end of the court sanction. So that includes time served, any probationary period, restitution, and court fines or fees. So you want to make sure you've taken care of all of that, and then you have 6 months to wait, and then at that point you can apply if you've been convicted of a misdemeanor. If it's a felony, that applies after 1 year. So it has to be 1 year since the end of the court sanctions, end of time served, end of any type of probation, court costs, fines, fees, restitution owed.
Like Jerry had mentioned earlier, there are some cases that you can do record sealing immediately. Is there anything like that with CQE?
Well, the state actually just recently amended the law that allows people to apply earlier than the 6 month or 1 year deadline. But again, I would recommend reaching out to an attorney or someone else qualified to give this sort of advice because the provisions are somewhat detailed as far as, there's a provision around if you've been incarcerated, serving a certain percentage of your sentence, right? So it's best to reach out to someone, but again, if it's been at least 6 months or a year, 6 months for the misdemeanor and a year for the felony, you're likely eligible to apply.
Now, are there any other eligibility requirements?
Really the important thing about this remedy, right, is that it's open to almost everyone, right, for almost every case. So there's, like I said, there's no conviction limit, and for some of your less serious crimes, there's a number of barriers which you may be experiencing, which can be removed and you can receive discretionary attention for. Once you've waited the 6 months or a year, then you're likely eligible. You really, most people would find this a remedy to at least consider.
Yeah, definitely. Now, if someone's ready to do the CQE application process, what are the steps that they need to take?
So the process is, a little important to consider. So the first process is you want to make sure you're eligible. So that's thinking about how long has it been since the end of my court sanction or supervision, right? If it's a misdemeanor, it has to be at least 6 months. If it's a felony, it has to be at least a year. And then you begin the process online, actually. So there's a website. It's drcque.com. And you visit that website and you create a profile. And then you begin filling out the information. From there, the state, the Ohio Department of Rehabilitation and Corrections, reviews that application for completeness and correctness, right, to make sure that you've listed all your records, all your conviction history, you've answered all the questions, listed appropriate information, and then they send it back to you and say it's ready to file, and then you go to the Court of Common Pleas in your county. At that point, you file in the Court of Common Pleas, and a judge has an opportunity to review it and to decide on it. Then it goes back to the Ohio Department of Rehabilitation and Corrections, and they issue the actual certificate. So step 1, make sure you're eligible. Step 2, go online, drcque.com, fill out the application. Then you go to the Court of Common Pleas in your county, and then you can, once it's been granted, go back to the DRC, the Ohio Department of Rehabilitation and Corrections, and they will grant you or present you with the physical certificate.
Now, how I asked earlier with Jerry about the record sealing, like if someone was convicted here but they moved elsewhere, is it the same process when it comes to this?
Well, so whenever you're applying for the CQE, you're going to apply in a county where you have a conviction. So, this is a little confusing, so I want to make sure I go through it slowly and appropriately. So, if you were convicted in a municipality, in a city, for example, if you were convicted of a crime in the city of Cleveland, right? The city of Cleveland sits in Cuyahoga County, and so you would apply in Cuyahoga County Common Pleas Court. If you were convicted in Elyria, Ohio, right, again, a municipal court at the municipal level, you would then apply in Lorain County Common Pleas, right, so on and so forth. Now, let's say you have convictions in both, Cleveland and Elyria. You can choose to apply, you must apply in the city, or in the county in which you reside, right? So if you're residing in Cuyahoga County at the time, regardless of where you have your convictions, you would apply in that county. If you've decided to move outside of the state, say you live in Pennsylvania, but you're looking to come back into the state to begin working or to get a license, then you're going to apply in a county where you have conviction, right? So the example earlier, you can apply in either Cuyahoga or Lorain County. But that's only if you live outside the state, okay? If you're living in the state, you want to apply in the county in which you reside. On that note, the other important thing to mention is that the CQE, the Certificate of Qualification for Employment, only is able to apply discretion in these criminal records-based barriers that we discussed. It's only to apply to state barriers. These we call them collateral consequences, right? Consequences which accompany a criminal conviction, and they only apply to state collateral consequences, which again are separate from other states' collateral consequences as well as federal. Exactly.
So
as well
federal's
as federal.
A whole different ballgame.
Exactly.
So if you have a federal conviction, can you still apply for the CQE, or is it?
So it's not going to do you much good
Okay.
because again, these certificates reference barriers in Ohio state law.
Now, say someone has applied for this before, are they eligible to apply again? And has the law changed at all as far as how the applying process goes?
Well, so if you've applied before, you're likely covered. You can lose a CQE, right? So the way you lose a CQE is you've been convicted of another felony, right? Not another misdemeanor, not another minor misdemeanor, not a traffic offense. But if you've been convicted of a felony, then you will lose your CQE. If you've applied before and you still have it, it's still good, and you can still, carry on with it and apply to jobs or apply to get certain licenses. There has been a recent change for those folks that have been thinking about it but have heard that maybe it's too difficult an application. There has been a change recently as of last year. The state allowed for you to list more general responses in the application as to what you would like to do with the CQE. It used to be a little difficult to fill out because you had to identify, for example, Ohio Revised Code XXX and say, I want relief from this barrier. So the state has tried to make it a little less difficult, a little less confusing. And you can say, I want a CQE because I want a job, or I want a CQE because I want a nursing license, so on and so forth.
And you might get the certificate, but you may not get the job.
Exactly.
That's something that should be stressed, probably.
Exactly. So, again, the CQE helps remove these collateral consequences, these criminal record-based barriers, right? But it doesn't guarantee employment and it doesn't guarantee licensure. Most often, what we see is that a licensing board goes from having to on a mandatory basis or on an automatic basis, denying someone a license, to then using discretion. And that's still important, right? Because
definitely.
whereas, someone could have had a conviction from 20 years ago and been leading a law-abiding life for the past 20 years, they may have been, again, stopped at the door because of an automatic barrier. And so then it allows the licensing board or an employer discretion, right? But again, it's still only discretion. So the employer, the licensing board still has discretion to deny you despite having a CQE.
And again, you said to get help or assistance with this, Legal Aid Society.
Of course, yes. So here in Cleveland, or in the counties that we serve, right, we serve a 5-county area, including Lorain County, Cuyahoga County, Ashtabula County, Lake County, and Geauga County. You can contact the Legal Aid Society of Cleveland. Across the state, because again, this is something that applies across the state, you can visit ohiolegalservices.org, or you can call 866-529-6446 and reach out to the legal aid in your county and get help applying with the CQE.
And it's free.
It's free. The process to get help is free, but it's very important to mention that the CQE does have a filing fee, and those vary across counties. So make sure to get all your county-specific information from your local court of common pleas or from the legal organization which you're working with.
Is there anything else you think the viewers should know about CQEs in the process?
No, I think, again, it's just important to stress that it's something that's available regardless of the number of convictions, right? Mm-hmm. And again, it doesn't cover all the consequences which you may be experiencing, but it may help with one that's really just, getting in your way of moving forward with your life and re-entering.
That's great. Well, thank you so much, Andrew. We've learned so much today. This has been really informative.
Thank you for having me.
And thank you so much for tuning in. Of course, we'll have all this information on our website, tv20cleveland.com. Until next time, I'm Leah Haslich. Thanks for watching.